Hello, I'm Jennifer Zdriluk, and I'm here today with my law partner, Wade Poziomka. We're both lawyers in the Ross and McBride Human Rights and Employment Law Department, and we'd like to talk to you today about what to look for when retaining a lawyer. I think one of the first things that you need to look for when you're retaining a lawyer is the fit. And we can all say the fit, but what does that mean? Are you looking for a generalist who has the ability to give you some advice in a number of different areas of law? Or are you looking for a specialist who might know a little bit more about that area, may not, may have some more experience in a specific area of law? And, from my perspective, one of the things I think a specialist can do for you is maybe give you a little bit more reflection on what possible outcomes or possible events can arise while you're pursuing a case. I think that generalist, specialist, you choose, but you want someone who you feel comfortable, knows what they're talking about, and that they can assist you. And then I think another important thing to people is money.
Yeah, there's different types of retainer agreements that lawyers can offer. So the one that's most obvious is an hourly rate where a lawyer will work and be paid a set amount for each hour that's worked. You're billed at the end of the month. But often in my practice, which is human rights and employment, people have just lost their job and they don't have money available to, a significant amount of money available to pay lawyers with a retainer. And so what we offer as an access to justice tool are contingency fee retainers, where we take a percentage of something we get for someone in the litigation, but after the fact, when they actually have money in their pocket and they can afford to pay it. I find that most people do prefer the contingency fee retainers after they've lost employment.
No, I agree, and I think that's important. And I think another thing that we can do and you can explore is look at what we call fixed rate or limited scope retainers. Sometimes there's a belief that if you go to a lawyer, you have to go all the way to court and you're going to pay them a lot of money to go through a very long process. I know, Wade, you have, and I have as well, taken limited scope retainers where maybe I help someone just at a human rights mediation, or maybe you give them advice on a letter they're going to try to negotiate with their employer, right?
Yeah, that's a good point. I mean, some people ask whether we'll do pro bono legal work, and we do a fair bit of pro bono legal work, but we also have to turn down a fair bit just given how much we're asked to do that. The limited scope retainer agreements, I think, are really important because people who want to do their own hearing and who feel comfortable doing that can come back to us and ask us about preparing research for them, or looking at questions they prepared for a witness, or asking us how to deal with something unexpected that came up in the hearing. And so it's an affordable way to have some legal advice but not have full representation.
For sure. And to your access to justice point, I think that we know more and more people are involved in the legal process every day, particularly in the human rights and employment regimes, and that more people are trying to make do or get by or have chosen, because of their own expertise, to do so without a lawyer. And there are a number of venues in Ontario that you don't need a lawyer for, right? And I think that's another thing you have to think about when you're retaining a lawyer. Am I planning to go to the Court of Appeal with this matter because I'm appealing a decision that's already been done? In that case, I think you want a lawyer that you feel fairly confident with, has done appeals before, knows the law, is comfortable in a courtroom. Other times, you may be preparing your own human rights file or preparing your own small claims court file. And I think as much as possible, having a little bit of a map ahead of time as to where you might want to go and what you might want to achieve can help you in retaining a lawyer.
I agree. I think people really have to think about what it is that they want. What's the outcome they want? And, if you want to go all the way to trial or through a hearing because you want a public decision and you want to expose the employer for what, they've done something wrong to you, you have to understand that that's costly. So there's costs associated with that. Most of the time it's a financial equation. People want some compensation for what happened, but they don't want that all to go to the lawyer, understandably. And so settlement is often a really good options. Sometimes you can get a reasonable settlement up front with a demand letter. Sometimes you have to go through a few of the steps in the litigation process to get that settlement. And sometimes you have to go all the way. But typically, the longer you take in the process, the more expensive it is.
Absolutely. And I guess lastly, what I'd say, sort of what I started with, is you want that fit. And fit means something different to everyone. I think to me, and I know you share some of these beliefs, you want a lawyer who listens to you, a lawyer who respects you, a lawyer who keeps you informed. I think things like empathy are important attributes. But, I have, and I'm sure you have, some clients who don't want to be advised of every detail, either because they're too busy or because it's too painful. And you want someone who can hear what you want and deliver what you want, or tell you if they can't.
It's a good point. I always tell people up front that I can't get back to them the same day. My practice is really busy and I don't have time to do that, but I do try to get back within a day or two, even if it's an email to set up a phone call. So I think it's important that people trust their lawyer, and there's that discussion at the outset about what expectations are. If you need someone who can respond to you the same day, I wouldn't be that lawyer.
For sure. And I guess lastly, my piece of advice would be ask your lawyer questions. Never feel afraid, in my opinion, to find out what they can and can't do, and we can or can't deliver, and just ask those questions.
And ask tough questions up front. And you can ask about different fee structures. It's okay to ask about pro bono work, if there's availability, contingency fee arrangements, block fee arrangements, where the lawyer estimates, what type of, or how much it will cost for each stage of the litigation, and you pay per stage, and there's no commitment to continue or carry on. Or you can even ask for reduced hourly rates. The worst that someone's going to say is no.